my friends. This is Vinneychopra, and that's John Rusin with me. I know Alicia Debral is not here with me, my co-host. She was in hospital yesterday. I wish her very well. She'll be fine. But I wanted to really come live because we got a tremendous, well-known personality in USA, Mauricio Rauld, my good friend, and he's from California, and the attorney. Let me kind of introduce you, Mauricio, formally, and then we'll dig into it. Good stuff, bud. Mauricio Rauld, right here from Southern California, known as one of the few lawyers that actually speaks English. I love that. Mauricio helps real estate syndicators stay out of jail. I love that one. By ensuring compliance with federal and state securities laws. With more than 20 years of securities experience, Mauricio is the premier syndication attorney in the country, focusing exclusively on syndications for real estate investors, not real estate, just the SEC, the syndication world, which I have been living in, for the last 14 years. So Mauricio has been recognized as one of the top California attorneys under 40. By such a young age, he's able to accomplish so much. I'm so inspired to have him here. Under 40 by Super Lawyers magazine, and also an educator at heart. That I love it, because that's why he can speak English, and language to teach us all in this podcast, all the ups and downs and everything that we'll be asking Mauricio. And Mauricio, right? Yeah, regularly travels around the country speaking. And actually, we met last year in Dallas at Michael Blank's show. I know he's been on many shows, Rod Cleave show, Ken McElroy show. All the great, personalities have had him, on their podcast, speaking real estate investors on how to legal piece together, how it fits into the overall syndication puzzle, which a lot of us are bombarded with. As a matter of fact, we are asking our, partners to raise money and things like that. A constant on the real estate investing podcast circuit. Mauricio is a regular contributor to the Real Estate Guys show, radio show. Very nice people. I met them there in Dallas, and he has also been featured, like I said, Lifetime Cash Flow through Real Estate with Rod Cleave, my good friend from Florida. Actually, Kevin Buck was also on my podcast, great friend of Rod, and we hit very well. And then of course Ken McElroy podcast, and you're starting your own. Mauricio, I'm so glad, buddy. I can't wait to tune into that one. Hey man, I need everything, legal, right? Because to keep our businesses alive, and that's the key. A graduate of the University of California at Berkeley. Our son went to Berkeley, by the way. He did EECS over there. Mauricio lives in Southern California with his wife, Heidi, and their little angels, Adelina and Alexandra. Welcome to the show, Mauricio. I'm so privileged to have you, bud.
Thanks so much for having me, Vinney. Really looking forward to spending some time with you and John. Thank you for having me.
Such a pleasure. Let's start, if you could, kind of tell us how you got into syndication, field attorneys rather than any other, law practice.
Yeah, right out of law school, I had the privilege of going to a fairly well-established large law firm, and that's where I started practicing securities laws. Now, back then it was a little bit different because I represented sort of the big brokerage houses, the sort of the Goldman Sachs and the JP Morgans and the Merrill Lynches of the world. But I was a defense attorney at that point. I was actually a litigator. So my involvement happened at the end when somebody got sued, when Merrill Lynch gets sued or Goldman Sachs gets sued. I would be the defense attorney representing them. So that's how I started on the security side. But I'd always had interest in real estate. And just to make a long story short, I wasn't super happy in the law firm life. I just knew there was something better out there. And I was fortunate enough to come across this amazing little purple book called The Rich Dad, Poor Dad,
Yes.
as you know well, and a lot of your listeners know well. Yeah. And that eventually led me to the real estate guys who are very well connected with Robert. And I went to one of their seminars and ultimately left the private practice and went to work as general counsel for the real estate guys and their operations. And so that's really where I started doing syndication. This was back in 2005. So it's been 15, 16 years. Where I would then handle, back then the real estate guys were Robert and Russ were doing a lot of syndication. So I was handling all the syndication work over there as their general counsel, and also actually doing a lot of asset protection, which is why I have that skill as well. But that's how I got involved in the syndication. And obviously as their group grew, I ended up, helping a lot of their members and a lot of their clients, and basically spun off my own business from that. Obviously kept the real estate guys as a client, VIP client, but then basically started building my business back in 06, 07. And, at the beginning, you basically do anything that puts food on the table, right? So it was securities, it was asset protection, it was, whatever you need. But over time, I've narrowed my focus to the point where today, 100% of my practice is syndication, and all of my clients are real estate syndicators. So that's my exclusive focus, and I really focus on Reg D, which is probably what most people rely on. We obviously, our practice has grown now, and we do have a real estate attorney, a transactional attorney that can help clients with that. But my focus is exclusively on the syndication world, which, as you know, Vinney, is just a fancy way of saying I'm an SEC lawyer.
Well, very important one.
Yes.
I mean, Mauricio, I've been in this world for 14 years, and I think my whole success has come because of syndication. And that's why I wrote the book also, right?
Great book.
Made Easy, because it's the pooling of money legally to be the fiduciary responsible person for other people's money, take care of their money better than your money, and in a legal way to do everything correctly. And I want to say right away to the outset to my audience and yours who will be looking at and watching us, is that I've never, ever, ever felt need to reduce the cost of syndication fee at all. The reason is that's the best cost that investment actually we can all make to make sure that we are not really in any kind of jeopardy and wrongdoing into offering these PPMs, private placement memorandums and the operating agreements and, the subscription agreements and all the documents that go with it. So I have always taught my audience and my students that that's the fee you put it in underwriting. I mean, it's not a cost. It's an investment. It needs to be there.
That's right. It has to be there, and it does get paid out of the project. And honestly, on the real estate side, what I think a lot of syndicators miss is we actually have a lot of efficiencies already because we're constantly doing real estate. If you go to a firm and have a syndication on, let's just say a startup or whatever, it's not uncommon for that to cost you 20, 30, 50. I've had clients spend $100,000 on private placements because it's a complicated, phase that they're doing. So when you're doing real estate, we do have efficiency. So the cost really isn't as bad. And as you mentioned, Vinney, it's paid out of the project. And so you put it into your underwriting, into your budget, and you just put it in there and it just gets absorbed by the project.
Totally, Mauricio. And, I remember in the previous, many years back, people said, oh, could you share with me the people? I said, why do you want to share? I mean, you're going to copy it and do it? I said, you're crazy. You can never. Can you say something about that? Oh my gosh.
Look, the PPM, and we'll be getting a little ahead of ourselves, but in and of itself is really worthless to you, your individual situation. There are plenty of PPMs you can get off the internet, right? But the PPM itself is worthless unless you know what information to put inside the PPM, right? And that's the role of your lawyer. The role of your lawyer is to essentially interview you, understand your exact specific deal, and pull that information from you, all the risks involved with your particular deal, all the disclosures for your particular deal, of your particular market, of your particular lending, your specific deal, and put that information into that PPM, because at the end of the day, a PPM is simply a disclosure document for those investors so that your investors can make an intelligent decision with all the information available to them.
So true. So nicely put together. You're so right. So let's just kind of dig into it. So to stay out of jail, what an investor needs to do, a passive investor and a syndicator needs to do.
Like just off the bat, the jail, the reason I use the word jail is to really get people's attention, because I feel like a lot of people just don't take securities laws really seriously. Yes. Look, the odds of you going to jail are very slim. I mean, you've got to really be doing, you can go to jail for sure, just ask Bernie Madoff, but you really have to be doing fraudulent, intentional doing, which most people aren't going to do. But there are very severe consequences by not following the rules. Just right off the bat is you'll be barred from ever doing it again. So, I mean, if this is something you're thinking of doing for a living and you violate securities laws, there's a good chance you won't be able to do it again. And then the real penalty is rescission, meaning you've got to return, even if it wasn't your fault, you have to return all of the investor's money back plus interest. And there's a good likelihood that you don't have that money. So you're going to end up filing for bankruptcy. It's going to be a disaster. So it is very serious consequences. And that's why you want to have a securities attorney involved in your team. This is not a do-it-yourself project. Your attorney really needs to be part of your team, advising you. And that's what I really think of myself as, an advisor. Yes, we draft documents and we do all that stuff, but we really advise our clients as to what exemptions we need to follow, and then what are the steps that we need to follow. What can we do? What can't we do to make sure we're following those rules that we've selected, and so we stay on the right side of the rules and not get into trouble and start making illegal offerings, which is the ultimate thing we're trying to avoid.
So very true. So very true. Mauricio, so what would you say are the downfall of a young syndicator?
Yeah. Look, for hands down, first-time syndicators or young syndicators, the biggest mistake they make is not realizing that they're involved in issuing securities in the first place, especially our young real estate investor, right? Real estate syndicators say, wait a minute, I'm just buying a home, or I'm buying an apartment building, or I'm buying whatever I'm buying. Like, why in the world is the SEC involved? Why do I even have to worry about the SEC? I'm not buying securities or selling securities. I'm not Goldman Sachs and stock market stuff. I'm just buying a building. Like, why in the world is that? And as you know, Vinney, the definition of a security is so broad that it includes essentially any time you're collecting money from investors, from passive investors, where the returns are generated by your efforts. Anytime you're taking passive money and you're generating the efforts, that is a security. And the structure itself does not matter. If it's an LLC, a handshake, a tenants in common, a joint venture, the structure itself does not matter. I think that's the biggest mistake. Folks think they raise the money and they don't realize they're doing an illegal offering. Because as soon as you realize that you're issuing securities, as I like to say, three things. One, register the security with the SEC, which, by the way, we don't want to do. Or we have to find an exemption to registration, or it's illegal. That's it. Those are your options. So when you don't think of these things, you end up doing illegal offerings because you don't prepare the proper documents, you don't make the filings, you don't get an exemption. And so that's really probably the biggest mistake I see out there for first-time syndicators.
So with the rise of social media, so now today I can post a post and reach thousands, if not millions of people. So alongside that, there's been a rise in people being capital raisers. So what is a legal way, or how are you seeing syndicators compensate or structure people that are trying to do this when they're not broker dealers? Or do you say don't do it, stay away?
Two different things. So you've actually hit on you've hit number 2 and number 3. So number 1 was not recognizing you have a security. Number 2 is advertising on social media when you're not supposed to. And number 3 is raising capital with people when you're not a broker dealer. So you've kind of hit all my strong points here. So let's take broker. You want to start with broker dealer or social media? You tell me.
Oh, broker dealer, let's go with that. And defining, then we can go to social, then we can do money raisers.
Yeah, the money raisers is becoming a big issue because, back in the day, and I always joke, back in the day was 2 or 3 years ago, you would typically see my clients would be one syndicator, Vinney. Vinney's raising the money, Vinney's the guy. And then, sometimes you'll see Vinney and a partner. Maybe Vinney and John get together and there's 2 of you that have started a business and you raise money. That's fine. And then occasionally you'd see the third person because maybe, there's a market that you're not familiar with. And so somebody's, knows that market really well, boots on the ground, all that stuff. But what we're starting to see now is more and more people start becoming part of this GP or general partnership or the syndication group. And I see now where you have 6, 7, 10 people involved. And people have lost sight of the fact that the general rule is that you cannot get compensated for raising capital for other people unless you are a licensed broker dealer. Okay. Sure. Now, as the person, if it's just you and you've got an LLC and you're raising money, there's something called an issuer exemption, which which allows you to do that because you're not raising money for other people, you're raising money for your own account.
Sure.
But once you have 2 or 3 or 4 people, actually the general partners of the syndication or the managers or whatever, they don't get to enjoy that issuer exemption. We have to find a different way to make sure that they don't have to rely. And there's a safe harbor. It's called not to get too technical, it's a 3A4-1 exemption. But essentially, the bottom line is there's a couple things that have to happen, which again, if it's just you and John and me, we're not going to have an issue with this. But number one is we cannot get paid transaction-based compensation, meaning I can't go out and raise money and then get paid based on whether that money comes in or not. It's based on that transaction. That is the hallmark of broker-dealer transaction. So you cannot get paid to go raise money, essentially. What you need to get paid for is you must be doing substantial work inside the syndication. So obviously, if it's just you, you're doing all the work. And if it's you and John, you both are doing the work. And with 3, but once you get to 8, 9, and 10, it gets harder and harder and harder to show that all of you are engaged in substantial duties. Mm-hmm. And second of all, your primary focus, your primary role must be doing that substantial duty, not raising money. So you have to spend more, in my mind, more time doing the thing than raising the money. Raising the money is incidental to what you're doing. And the problem we're seeing these days is we have a lot of people out there that are they're part of the general partner, they're part of the syndication, but all they do is they go out and raise the money, bring the money into the deal, and then they're done. They do no other work. And that's where the SEC is starting to focus on that. And a lot of people are starting to get into trouble because they're not realizing, again, maybe they don't have a securities lawyer and it all looks kind of simple. And sometimes we make it look simple, but there's all these things going on in the background. We have our little bag of tricks that we're always checking on. And every so often an issue like that pops up and we would address it. But if you're not working with a good securities attorney, you don't think of these things. You don't realize that what you're doing violates broker-dealer rules.
Surely. How about joint contracts? I know like some people say, oh no, I've just got my family's money, right? And I'm buying this real estate, but they are entrusting them to make the profit. So of course, TICs, right? Tenants in common is one way where everybody has to be materially involved, right? On a daily basis. I think there is a word daily basis also, right, Maurice?
We go back to the original definition, which I mentioned, which the structure itself, tenants in common, joint venture, LLC, that doesn't matter. The question is everyone doing active work? Is everybody participating so that the returns are not generated by the efforts of one person, but the returns are generated by the collective efforts of everyone? So if I've got 4 people coming in to do a tenants in common or a joint venture, as long as all 4 of us are actively involved, then that's not going to be a security. But the minute you get one of them that's just kind of sitting on the couch, writes a check, and the other 3 do all the work, that's where you start getting into the issues, because now you have one person who's really a passive investor, and the returns are not being generated by their efforts, they're being generated by the efforts of the other 2, 3, or 4 people.
Beautiful. Could you kind of take us through, like when should the young syndicators get in touch with the syndication attorney and how they should really get started and, the whole shebang, right?
I believe that, at a minimum, as soon as you get into, as soon as you have an LOI that's been accepted, that you're about to get into contract, you should be reaching out to your attorney. I've heard a lot of people say, look, wait until due diligence or wait until you figured out that you're actually going to do the deal. And that may be fine as long as you're not talking to anybody, right? But the minute you're starting to show some information and talking to investors, you need to be worried about the securities laws, because the first thing we're going to do at our initial call is determine what exemption we're going to rely on.
Right.
And based on that decision, there are things that we can do and things that we cannot do. And so if you wait till the end, and I've literally had calls with people that call me at the end and say, look, we're closing, I've kind of raised all the money, I just need the documents, just let me know. And it turns out that they may have advertised on social media, not knowing that that would prohibit them from relying on this exemption, which would prohibit them from having, for example, non-accredited investors. And so you've got to come at the beginning so we can lay out the groundwork, the foundation of what the steps are for this issuance, the security issuance, and follow those rules. If you come too late, then there's a good chance you may have done something already that would preclude us from relying on an exemption. And as you know, Vinney, there's really one or two exemptions that 95% of the people rely on.
Yes.
If you're no longer allowed to rely on that exemption because of something that you did unknowingly, then that creates problems, when you do finally call the attorney.
Makes sense. Totally makes sense. So like, exemption D, of course, we do 506B, and the C, of course, in C, we can advertise till the blue in the face. And in the B, we just can't. And also the big thing is, Mauricio, isn't it like your database freezes when you sign a deal? So you have to have pre-existing relationship. Could you kind of talk about that and the curation period? That's something I've also heard, in the last 14 years. Yeah.
I've done a couple of videos about that because it's a very popular topic. So if you're relying on this exemption, so remember we said everything needs to be either registered or you have to find an exemption or it's illegal.
Yes.
So one of the exemptions that you reference is 506B as in boy. And it's a great exemption. 90% of the people, more than 90% of the people use it. But one of the prohibitions in that exemption is that you cannot advertise or solicit, going back to John's allusion earlier about social. So you cannot go on social media, post your deal, or go on your great podcast and tell the world that they have an offering. That's just not allowed. No. And the way you essentially prove that, or the way you go about showing that you did not advertise, is by showing that you had a pre-existing substantive relationship with your investor.
Yes.
Now there's two words to that. One is substantive, and substantive essentially means that you've gotten to know them well enough that you're able to determine whether they're a sophisticated investor and this is suitable for them. Meaning, that they have the requisite experience to evaluate the merits and the risks of that particular investment, right? Sure. And so there's actually one of the few areas where the SEC has given us some really good guidance on what constitutes a substantive relationship, or how do we get there. And so I actually did a video that goes through, and I'll go through it again here, but how do you take a complete stranger that you met at a meetup or wherever, we talked about Michael Blanc's event, like any of these events and seminar, how do you take a complete stranger and establish that substantive relationship? And the SEC has come out with some guidelines, and there's basically 5, 6, or 7 items that you do. The main ones are a really detailed questionnaire to your investor so you can figure out what their level of sophistication is, their net worth, their experience, a phone call or a cup of coffee or a lunch meeting or whatever to have a one-on-one. And then all these other things that essentially foster this relationship. You're really trying to get to know the investor well enough that you can say, yeah, you know what, I've talked to Vinney now a few times. I've gotten to know Vinney. And Vinney really is a sophisticated, he's got a lot of experience. He's got a high net worth. I believe that Vinney has the experience to really evaluate the merits of the risks of my investments. So sure. I'm going to say, as of today, I have a substantive relationship with Vinney. And there's no, SEC was very clear, there's no magic timeline. There's no 30-day rule that people used to throw out. There's no 3-touch rule that people used to say. Right. It's the quality of the interactions between the two of us that matter. So again, I always give the example, with the real estate guys, we used to go on all of these field trips, real estate field trips. And so one of them used to go down to Central America and Belize, where I spent some time. And you would literally spend 72 hours with everyone, all these investors, 72 hours. You would wake up, have breakfast. You would spend the entire time. I assure you that when you leave that trip, you know that person really well. And you contrast that with somebody that you may have known for 2 years, that you've maybe met once or twice, or you see them once a year at at these events. The timing isn't important. It's the quality of the interactions. And you're right. The other part of it is you have to have a pre-existing substantive relationship. And that means pre-existing the offering. And so then the question becomes, well, when does the offering begin?
Yes.
Right? Because as soon as you determine when the offering is, then like you said, everything freezes. You cannot add more people to your date. You can add more people to your database, but not offer them that deal. And so in my opinion, there's some people that say, wait until you hire the lawyer, or certainly when you hire the lawyer for sure, you've thought it, but it can certainly happen before that. I mean, even before, if you get in a contract and you haven't even signed a contract yet, but I'm sitting with you over lunch with a spreadsheet and my laptop and showing you some projections, some ideas, that could be clearly, could be considered, making an offer or showing them part of your offering. So, and certainly I've got some clients that like to send emails, and you know them as well, emails ahead of time, which is nothing wrong with that. Like, hey, looks like we're going to be in contract with this building, and I'm letting you know some details, stay tuned. I'll send you more information later. Those would all be facts. It's all facts and circumstances, but all those would be facts to show me that the offering has indeed begun. And once it begins, any new people that you bring on or new people that you establish substantive relationships with would not be eligible for this particular deal. You would have to wait until the next deal once you establish that substantive relationship.
So true. The future deal,
Yeah, the future
and
deal.
we are always cultivating, new and new investors. Like I have 176 now, I think, with the grace of God. They're very high, powerful people, and I've sold 28, 22 of the 28. So you've given millions back to them, triple their money, whatever, So they're bringing back money. And no, thank you so much. So there is not such period like 30-day curation period at all.
The only time the 30 days these days comes into play as sort of a recommendation is if you are doing what's called a continual raise, meaning you're doing a fund typically, but let's just say there is no end date. So there's no start date, no end date. There's a start date, but there's no end date. So what happens if this is a fund that you're raising for 2 or 3 years and then you meet somebody, well, you obviously can't wait for the next one. There really isn't a next one. So the rule of thumb there is if once you establish that substantive relationship, you would want to wait at least 30 days before you offer them that thing. But if it's not a continual fund, there is no magic there. You could literally meet someone in theory today, and then by tomorrow you're having lunch and coffee and spend the whole day together, and you could have established that, in theory, substantive relationship in that time period.
Sure. Let's go into the money raisers then. I mean, that's a very sticky subject, I know. And, thank God, we are able to raise a ton of money, which is good, and don't need that many partners and all. But you're right. I mean, some people, we hear and see, they are having. So what's the legal way to do that, if there is one?
The legal way, there's 2 ways to do it, really. The easiest way, if it's true, the problem is a lot of times you try and fit, you know what the rule is, and you're trying to fit your scenario into the rule, which is the wrong way to think of it. But if you are legitimately, what I call it, a legitimate co-sponsor, right?
Yes.
If you're one of the people, one of the 2 or 3 people, or it could be 4, there's no magic number, but you're one of the legitimate co-sponsors and you're doing real work. You're helping with the due diligence, you're helping with the underwriting, you're helping with the asset management, you're talking to the property managers, all the things that syndicators do. And as you know, Vinney, there's a whole laundry list of things that syndicators need to take care of. That's why I always say this is just the legal piece of the syndication puzzle. There's a huge puzzle that you're putting out there. So as long as they're doing real work, just think of it that way. They're doing real work, meaning they're doing substantial duties and their primary responsibility is to do the duties, not to raise money, then you're fine. You're fine. The other way that we talk quite a bit about is if you're somebody who really is really good at raising money and you don't want to be involved in the day-to-day, you don't really want to be a legitimate co-sponsor, you just want to be able to raise the money and invest it, and give it to you, for example, Vinney, then obviously you can get a broker-dealer license, but that's not really realistic unless you really want to do it. So one of the things we talk about quite a bit is this concept of a fund of funds. So it is possible, let's say Mauricio is a really good money raiser. I've got a huge audience and I want to raise money. What I can do is create my own fund. I can raise money into my own fund. And then that fund would then invest in Vinney's fund and invest in John's fund, invest in somebody else's fund. That would be kind of called a fund of funds. And that would be, I would do it legally, complying with the security laws at my level. And I would be making all the disclosures. I'd be doing a PPM. I'd be doing all those things legally. And then instead of buying a piece of property, like I typically would, I'm saying I'm going to invest in other people's deals, like Vinney, like John, like whoever. The wrinkle that you got to be really careful about is if you ever do that, then now you're technically investing in somebody else's company, not real estate, right? Somebody else's company. So you become, really, you're buying securities at that point. So you become an investment advisor. That's the next wrinkle to that. And so now we have to go back to each state, not each state, the state that you live in. What state do you live in? And go find out whether there's a requirement to register as an investment advisor, or if you can get around the rule, not around the rules, but if there's an exemption to that registration, which there usually is. But sometimes there's conditions, and so there's just another level of scrutiny that we have to look at. But in theory, that's how you would be able to legally raise money, quote unquote, for others. You're not really raising money for others. You're raising money for your own account, and then you're investing in somebody else's deal.
So
but
the word
that, you want to do the real syndicator, a legitimate co-sponsor is really the way to do it.
Surely. And Mauricio, like I've heard, like you have to be the issuer, right? They are your investors. You have pre-existing relationship with them. I'm talking about somebody who's raising money. So they have to be the issuer of the PPM and everything, where their contacts are investing in that fund of the fund, which will then, be specific offering, could be,
Yes.
that they will raise that much and put it into the other offering, I heard,
Yeah.
or they can be doing it in a blind fund, right?
Yeah.
That's the other word,
Most of the time, they're doing it more of a blind fund where they're
Okay.
raising capital and they're going to put a little bit into Vinney's deal, a little bit into Mauricio's deal, a little bit into John's deal.
Nice.
But as long as you're just aware, again, you want to be working with that attorney, because that's something that
Exactly.
working with a non-securities attorney, this thing wouldn't even come up. And so you just know that that's out there, that now you're an investment advisor, and we got to figure out all the rules relating to investment advisor, which isn't as complicated as the broker dealer rules, but it is in that area of law.
Sure.
That you just want to be aware of it.
So how do they get compensated then? I'm sorry, I'm asking some very pointed questions. Yeah.
You get compensated with your carried interest, is what we call it, that sweat equity. So I would raise money into my fund, and just like you would take 20% of that, or 15%, or 30, whatever, or you can give them a preferred return, and then you can take the same compensation on the carried interest level that you would do on a syndication. So now you're investing that money into somebody else's deal. When that other deal sends you're basically a limited partner in that deal. When they send you money, that's basically your revenue. And that money then gets split however you agreed with your investors, 80-20.
With your limited partners. Got it. So actually, the person in the middle, is actually doing his own sweat equity. You're right. To find the best operators who have proven records, and to really find, the deals. Also, it's not that easy to find these kind of deals nowadays. So they're doing so much work that they can tell their investor base, hey, this is what my game plan is, and please invest with me, and I'll position your money to get great returns and so forth, and then have a split. I got it, 20-80 or whatever, right?
Yep.
Yes.
And remember, I always think of really three things that fund manager or that person's doing. Number one, they're doing all the due diligence, right? They're doing the due diligence. Like, let's say I'm going to put money into Vinney's deal. I've got to do due diligence on Vinney. I got to make sure he's good. I've got to do diligence on the deal that Vinney's doing. And that's all work that the passive investor who doesn't want to be involved in that just wants to check. You're doing all that work for them. The other thing that you're helping is, typically when you do something like that, you negotiate better deals with the operator, because now you're coming in with typically a larger amount of investment. So when I say, Vinney, I can come in with $1 million into your deal versus everybody else is coming in with 50,000. There's ways to typically you negotiate a little bit of a better deal that because of the power of the group. And then a lot of times also the deal might be really great. Vinney may have an outstanding deal, but your minimum may be too high for me. Your minimum might be, there's some deals that have a $250,000 minimum or $100,000 minimum. Well, I wouldn't be able to. I don't have that kind of money to invest in Vinney's deal, but I can use Mauricio's fund or whoever's fund whose lower limits will give me access to that deal that I otherwise wouldn't have access. So there's a lot of ways you can add value, and that's what you're getting compensated for, is adding that value to the passive investors.
Marvelous. So actually, I'm just thinking, being an engineer, I'm looking at the logics, right? So actually it could be the same deal, but then some of the investors who are in the other fund of the fund may get smaller returns, maybe. I don't know.
They may get smaller returns, but most of the times, we structure it so they at least get the same returns. And like I said, often they get better returns going through the fund, because again, they've negotiated a discount on the asset management fee, or maybe they're getting a discount on the carried interest. And so there's actually more money. Now the fund manager will split that with the investors, but the net of it might be that they get a better return than if they went straight to your deal. But at the very least, we want to structure it so they have at least the same amount. Otherwise, I would just go straight to Vinney's deal.
Right. And then also having the non-circumvent and all, that's very important, because I think, we have to make sure that they are not our investors. I look at it, it's the pre-existing relationship, right? With the people. Right. Sure. What else you could give as gold nuggets that I didn't talk about?
I think the other thing, just to kind of wrap it up there with what John was mentioning, the social media, right? So again, if you're going to be relying on an exemption that prohibits advertising, like a 506B, then you just want to be aware of what you can and cannot post on social media. And there's a lot of little gray areas. I've done videos on that as well, on how to use social media to really add to your list and not really advertise your deal, because you cannot advertise your deal. So there's all things going on there. But again, if you're relying on a 506B that prohibits advertising, you cannot post. Not only can you not post your deal on social media, you can't even do what's called conditioning the market, meaning posting something that gets people excited about your deal, even though you're not talking about your deal specifically or telling them to call you to invest in your deal. If you're posting things that get people excited, called conditioning the market, that can be also considered an offer of a sale of a security, which would then blow your exemption. So my recommendation typically is, if you have an active deal going, I would stay off of social media anything relating to your deal or real estate, or don't try to get too cute with it. If you're in between deals, that's when I think you can start posting some things, not about your deal or your but really value add would be a great way to do it. If you can put together reports on why real estate's the greatest investment vehicle of all time, why Florida is a great marketplace, or whatever, or do a webinar and get a lead capture, right? That's how you use social media. And then once you get that lead capture, remember, you can't offer them the deal. You've got to go through those steps to take them from that complete stranger to establishing that substantive relationship. But that's the way you use social media: posting stuff, invest in my deal, or here's a link to my website that's got the deal. By the way, websites are public too, so you got to be careful what you put on your website. So that's probably the other big mistake that, especially these days, a lot of people are doing. And the SEC in the States are kind of underfunded, so that's not typical. They don't have interns or staff perusing through everybody's social media to see who's violating. It's typically a tag along. So there's typically a complaint for something else. And then what happens, the first thing that happens with the complaint is the SEC or the state will open an audit, will open up an investigation. And that's when these issues will come up. And you may have been okay with the original complaint, but now they found out that you were advertising on social media. You no longer can rely on the exemptions. So now what? Now you haven't registered and you can't find an exemption. You're starting to get in trouble.
Wow, you've given so many golden nuggets. Thank you so much, Mauricio. No, really. And, the big thing is, let's just, if we can talk about what's in your life, if I can take you, what is a day like in Mauricio's life, with
Yeah, well, I'm well known, or a little infamous, of getting up at really ridiculous hours. I've got 2 little girls at home, and so I want to spend time with them. And over the years, it's evolved, but I get up really early. Although I've been slacking off a little bit lately with the whole pandemic, but it's not unusual for me to get up between 3:30, 4:30.
What?
Because what I'm trying to do is try and get as
gosh.
much as I can. What I really originally started doing is, my little girls get up at about 6 a.m. and 6:30. Yes. I want to be able to be there at 6:30 and not be distracted with work and, fix breakfast or what have you. And so getting those initial things off the table early is great. And then I also want to end early. I don't want to be working until 6, 7, 8, 9 o'clock at night. Yeah. I want to end at 4:35. And so that's how I've kind of, hacked that system, is I get up really early because I want to spend time with the girls in the morning. And then obviously, they go to bed early. Now I go to bed really early too. It's not uncommon for me to go to bed with my girls, and and it's maybe I'm asleep by 7:30 or 8. So
yes,
it's not crazy. It's not like I'm going to bed at midnight and getting up at 3. But if I go to bed at 7, it's not that crazy, right? But
come on, we can party then. We can party.
That's how my day starts. And then, most of my day is either doing content or, on the phone with clients or with new potential clients. And obviously got my team that does most of the servicing. But I obviously look at everything before it goes out. But that's kind of a typical day for me. I get up early, get everything I get to do these amazing podcasts that I love doing, and put out as much content as I can.
I love it, Mauricio. This is tremendous. Thank you so much for taking the time, to be on my podcast. And I'd love to be on yours when you get started.
I'd love to. I'd be honored to have you on the podcast when it's ready. Thank you for that offer.
Totally. I wish you all the success in the world, to you and your girls and your family, everybody. And again, how can people reach you?
Sure. Look, easiest probably through the website, premierlawgroup.net. I've also got my YouTube channel where I put a lot of content there. Actually, I just did one on the funds. Okay. So just not Google, but put my name on YouTube. And those are probably good 2 ways to find me.
Oh, wonderful. And we'll put them in the show notes, everybody listening to us and watching us. And Again, thank you so much, Mauricio, for being on the show. Hey guys, this is Vinneychopra. Again, Alicia is a little bit under the weather, and John Rusin is with me. And thank you, Mauricio. And we'll come live to you again next week. And please like us, give good comments, and so forth. Share also the podcast. We are here for you. And again, thank you. Be well, and we'll see you next week.
Be sure to listen to Mr. Smiles next week with more golden nuggets and top-notch coaching tips. You can reach him by going to Vinneychopra.com or texting the word syndication to 474747. Be sure to like, comment, and share to show everyone how Mr. Smiles has brought your apartment syndication business to the next level.